Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss a case law on Order 7, Rule 11, that is rejection of plaint. Order 7 deals with the plaint. Rule 11 deals with the rejection of plaint. In this connection, Honorable Delhi High Court observed that the courts must make judicious use. The courts must make judicious use of Order 7, Rule 11 for expeditious disposal of the petition. That means you have to think in a judicial way to dispose of the rejection petition. If you reject, okay, they will come for appeal. If you allow, they will be happy. But keeping it in suspended animation for a long time, it will cause definitely injustice to them. Ultimately, of course, the Honorable High Court, they have given the so-called positive judgment. Now you can read the case as Aseem Agarwal, she is a lady, wife, Aseem Agarwal versus Ashi Kumar. In matrimonial appeal, MAT number 113 by 2022, decided on 18th August 2023 by single judge or two judges bench. Two judges, Justice Naveen Krishna Bansal and Suresh Kumar Kait. Both of them, they have quashed they have allowed the rejection appeal under Order 7, Rule 11 and dismissed the earlier order given by the family court. That means rejection petition allowed at High Court. If it has been allowed at the trial court stage itself, they would have felt happy. This is what the High Court observed. Right. Now, this Ashish Kumar, that is here he is the respondent. Appeal was filed by Madam Aseem Agarwal. Whatever it is. So, the marriage between Aseem Agarwal and Ashish Kumar, it took place on 4/10/2009, right, in Railway Officers Club, New Delhi. At the time of marriage, the bridegroom, the relatives of the bridegroom, they said, we don't want any dowry. No demand of dowry at the time of marriage. And of course, they also put a condition that the boy will go to New Zealand in the next year or 1 or 2 years, and she has to accompany him. Happily they agreed, because New Zealand, it is a paradise. Particularly, it is a paradise for the pensioners in Australia. Right? Whatever it is, they are also agreeable. Right? The marriage is completed, the ceremony is completed on 4/10/2009. But on the very next day, that is 5/10/2009, the husband, this is Suresh Kumar, they have shown their real, and family showed their real colors. Right? When on 5/10/2000, next day, when she went to the, of course, she went to the parental house, and on 6/10/2000, after 3 days, she joined the in-laws family. At that time, they demanded additional dowry of 40 lakhs and also a BMW car. And when she did not accede to their demand, they hurled abuses on her. Ultimately, of course, she suffered the harassment for about 1 year or so, and she gave a complaint, police complaint on 7/9/2010. That is almost after 1 year, she gave a complaint that the husband married her by fraud. Please remember. Why? Because after the marriage, after 15 days or so, on 22/10/2009, to be perfect, he left for New Zealand and there is no intimation from him. So she filed a case of fraud against the husband. Right? So under section 12, she filed a complaint before the police that the husband played fraud on her, and therefore she has requested for the annulment or cancellation of the marriage, dissolution of the marriage. This is the case. Now, the husband from New Zealand, the relatives, through relatives, he filed a written statement. In this written statement, he clearly requested the court a request under Order 7, Rule 11 that the petition should be rejected because he did not play fraud on her. She is not willing to come to New Zealand. She is not willing to lead the conjugal life. That's what. So, actually, the legal point here is he wanted rejection of the plaint because there is no cause of action, because there is no fraud. Because there is no fraud. But the trial court did not allow his petition. It has dismissed his petition. The written statement was taken into consideration. Other statement, the trial went on. So ultimately, there is one part. Agreed by the order of the family court. Then he filed an appeal before the rejection of plaint is equal to decree, So he filed a decree before the High Court. High Court has clearly stated that, please remember, fraud, not every misrepresentation, not every concealment of fact is fraud. So you have to prove the fraud. Fraudulently, dishonestly, means the intention should be there. The intention, why you are going to marry a woman, definitely for procreation or for development of your heritage, is it not? So, the husband wants to support or wants to, yes, definitely support the name of female. That's why he gets married. He did not play fraud. Of course, the demand of dowry, it is a point to be elicited during the legal course. Demand of additional dowry, otherwise. But she did not she did not play emphasis on that. She emphasized that he played fraud. Then he said there is no fraud, so no cause of action, so rejection of the plaint. But High Court, yes, even though the family court did not agree, High Court has clearly noticed that, yes, the marriage cannot be annulled because there is no fraud on the part of this boy. So the plaint has to be rejected. Order 7, Rule 11 allowed. So this is the beauty of this case. So it may be difficult for you to understand, to take the essence of the case because we are in the nascent stage. So please see my video twice or thrice and then only you will get benefited. If possible, please read the judgment and enrich your legal knowledge. Thank you.